Sorry, Your Honor.
Mr. Noe, are you ready to proceed with Mr. Bauer?
I certainly am. If I can get him on the screens in my office, I'll turn my other device around.
Okay.
Devin, just spin that around so the judge can see you. I know that laptop's not in the best shape.
All right, this is file 25-22347-FH, People of the State of Michigan versus Devin Michael Bauer. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, going to have the attorneys place their appearances on the record.
B.B. McClure on behalf of the people.
Good morning, Honor. Charles Noe, appearing on behalf of and with Mr. Bauer.
All right, and Mr. Noe, where do we stand with Mr. Bauer's case today?
Your Honor, I've had a chance to discuss this, obviously, both with the prosecution and also a couple of meetings with the court. My client is going to avail himself of the plea agreement, count one, plead to count one and count seven, with the remainder dismissed at time of sentencing. There is a Killebrew agreement to 24 months MDOC. Although I did want to place on the record that I will be arguing at that point for a reduction to a lesser sentence than that, for reasons that I'll place on the record at the time of sentencing. But also my understanding is if the court is inclined to agree with me and lower the sentence, the court would be the prosecution would be entitled at that time, if they wanted to withdraw their plea, they could. Just as if the court were to go above the 24 months, my client would have the chance to withdraw his plea. But at this time, I believe that would be a complete resolution of this matter. And I believe that the agreement is that this sentence, if the court were to impose a sentence, this would be concurrent, not consecutive, if I remember correctly. I believe that's it.
Okay, so just with respect to count seven, that charge under the statute, a consecutive sentence may be imposed for the underlying conviction.
I understand that, and my understanding is that the agreement with that would be concurrent.
Oh, I'm sorry, I misunderstood. Okay, Ms. McClure, is that a complete and accurate statement of the agreement then?
That is correct, Your Honor.
Okay. Mr. Noe, do you have a signed advice of rights form from Mr. Bauer?
I don't, Judge, but I'll take care of that today. That's my apologies. I should have taken care of that ahead of time, and that'll get sent today.
It needs to be taken care of now before he pleads. He needs to sign it.
I'll have him take care of it.
All right.
If I can have just a few minutes to get that done, Judge, we'll get that done and send that into your court.
Yeah, go ahead. Mr. Murphy, you have Mr. Spesser here?
Let me go check the hallway, Your Honor. Joseph Spesser? Does not appear so, Your Honor.
Okay, Mr. Do you have anyone that's here?
There's Mr. Allen here, Your Honor, Robert Allen. I believe he has a show cause. I didn't have it on my schedule, but if Your Honor wanted to do that, I understand it's just an arraignment today.
I don't have him on my docket. Do you have his case number?
I think he has a bench warrant, I guess.
Judge, there is
Did
a
you go
bench warrant for him. He was told to turn himself in this morning, so obviously he did. So let me check with the clerk's office and have him get you that file.
Okay, thank you.
Thank you. Then I think, I do have Michael Vaughn and Daniel Owen should be zooming in, and Jeffrey Bennett's in the jail, so no one else in person.
You need to speak to Mr. Vaughn before we start his case.
If I could please, Your Honor, I will go out in the hallway and connect on Zoom.
Okay.
Thank you. Bye.
Okay, Mr. Vaughn, I'm going to put you in a breakout room with Mr. Murphy in just a minute. He stepped outside to get logged in, so as soon as he does, I'll put you in a breakout room with him.
All right, thank you.
Your Honor, I'm sorry, could you send me the invite to join the breakout room again? Apparently I didn't.
Yeah, 1 second. Okay, Ms. Underwood, are you ready to proceed with Mr. Harris? All right, then you're back on the record, file 11-36322-DP, Crystal Marie Sauer versus Lloyd Raymond Harris Jr. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Mr. Harris this morning, Your Honor.
And do you know how Mr. Harris would like to proceed?
I believe Mr. Harris would like to enter a plea in this matter, in these matters, Your Honor.
All right, Mr. Harris, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Lloyd Raymond Harris Jr., correct?
Yes, sir.
Mr. Harris, do you understand that if you plead guilty today, that they'll sentence you to jail for up to 45 days?
Yes, sir.
You are entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
You're entitled to have all the witnesses against you appear at your trial, or you're ask those witnesses questions while they are under oath at your trial. Do you understand that as well?
Yes, sir.
You also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand that?
Yes, sir.
You are not required to say anything at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes, sir.
How do you plead to the charge that you failed to pay child support to the best of your ability up to the amount ordered?
Guilty.
How do you plead to the charge that you failed to appear?
Guilty.
Failed to appear in court for a show cause hearing on June 17, 2024.
Guilty.
So you have an old arrearage in this case in the amount of, oh, I'm sorry, it looks like it's $8,690.80. Do you agree with that?
Yes, sir.
And according to the friend of the court information, the last payment that you on that was back on March 15th of 2026 in the amount of $234. Is that correct?
No, sir. I'm not sure who made that payment. I did not make that.
Your Honor, it was an involuntary seizure. He has not made a payment on this case in over 3 years.
Okay. Do you agree, Mr. Harris, that you haven't made a voluntary payment in more than 3 years?
Yes, sir.
All right. And as a result of that, the court had a show cause hearing back on June 17, 2024, and you did not appear in court for that hearing. Is that correct?
Yes, sir. I did not receive anything saying I was supposed to show up.
Is your address still at 8085 St. Clair Street in Morenci?
No, sir, it is not.
Did you ever come to the front of the court and update your address?
Yes, sir, I did. It was supposed to be 8106 St. Clair Street.
Okay. All right.
Obviously, you got it on record.
So I'll accept the plea on the failure to pay. I cannot accept the plea on the failure to appear in court because Mr. Harris is not admitting facts that would constitute the.
Thank you.
Is there anything, Ms. Underwood, that you want to say on behalf of Mr. Harris before the court passes sentence on the failure to pay?
Just briefly, Your Honor, Mr. Harris needs to get to the Health and Human Services building and get some ID, Your Honor. Mr. Harris states to me he has tried to get ID for 2 years and he has been unable to get that. He has a problem and he has no social security card or no ID, Your Honor. That obviously is a problem getting work. I've explained to him that he needs to do that. I've explained to him further that he needs to get into the front of the court and have a review on this matter, Your Honor. It's a very old case and he's got a big arrearage, so which will not be affected, but it's still collecting. So he needs to do these things and be proactive to do them. Mr. Harris, I don't believe has money to make a payment, Your Honor, but I think having, what I would like to see is Mr. Harris released and given a time period to do these things and come back for a sentencing, Your Honor, but the court, is within its rights to do, of course, whatever it wishes. But I think something needs to be done to aid Mr. Harris or to give him incentive to get in and get some ID and get these things going, Your Honor.
Sir Harris, is there anything you'd like to say on your own behalf before the court passes sentence?
No, sir.
All right, so this is Mr. Harris's third contempt in this case, and I agree that he needs to do some things so that he can go out and find a job, but the reality is he needed to do those things a long time ago, and I don't know that giving him additional time to do that now that he's finally been picked up on this warrant, is the appropriate thing to do. It will be the sense of the court that Mr. Harris served 45 days in the Lenawee County Jail with credit for 1 day served. Obviously, the court is more interested in getting the child support paid than anything else, but so if he can pay $1,000, I'll allow him to be released early from that sentence. All right, Mr. Harris, you can let the officer with you know that you're done with court for today.
Okay.
Sir Fry, are you ready to proceed with Ms. Pate?
Yes, sure.
All right.
Okay, this is file 25-22449-FH, People versus Savannah Ray Pate. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Allison Arnold for the People.
Brian Fry for Savannah Pate.
And Ms. You are Savannah Ray Pate.
Yes.
Mr. Fry, where do we stand with Ms. Pate's case today?
Yes, Your Honor. This past week, we did receive a plea offer from the prosecutor's office. I just had a chance to discuss that with my client this morning. My understanding is part of the plea agreement, the prosecutor wants my client to physically sign the plea agreement form versus just placing it on the record. So, you know, due to that, and I also would need her to sign the advice of rights as well if she wishes to take the plea, which is my understanding. I think she does. I'll need a little bit more time to accomplish that. So if we can set this over for a week or whenever the court's next available is, it seems like we might have a resolution to this case.
Okay, Ms. Arnold, anything that you would like to add?
No, other than I'm not here on the 6th, but I think someone else can cover the plea or whatever else needs to be done if the court wants to set it on the 6th.
Okay. Why don't we adjourn it then to May 6th, next Wednesday? We can get that taken care of. Mr. Fry, can you prepare a stipulation in order?
Yes, I can do that. Ms. Arnold, can I sign your name to that with permission?
You certainly can.
Thank you.
Okay, so Ms. Pate, your next date is May 6th at 8:15. You can log in using all the same Zoom information you used to log in this morning.
Okay, thank you.
Thank you.
And
Go ahead and
Judge,
log
the
out.
court asked me what, I'm sorry, the court asked me what files I was here on this morning. I forgot, I'm also here on Maurice Jones.
Okay.
Thanks, Judge.
Sure.
All right, Ms. Underwood, are you ready to proceed with Mr. Novak?
Yes, please, Your Honor.
This is file 24-51863-PP, Ashley Carpenter versus Montana Novak. We are here today for a hearing on a show cause for alleged violation of personal protection order. And we are proceeding today partially in person, partially by video conference. Ms. Underwood, would you like to place your appearance on the record?
Ron Underwood for Mr. Novak this morning, Your Honor. Thank you.
And sir, you're Montana Novak, correct?
Yes, Your Honor.
All right, Ms. Underwood, where do you stand with Mr. Novak today?
I've discussed this matter with Mr. Novak, and we would ask the court to enter a not guilty plea on his behalf and set this for an evidentiary hearing, Your Honor.
Okay, so
Your Honor, there is something that people need to bring to the court's attention when it's appropriate.
go ahead, Ms. McClure.
I'm not sure if Miss Carpenter has hired an attorney or not, but our office is actively prosecuting her for an open case, so I don't think it would be appropriate for us to represent her on a PPO violation hearing. I know we haven't had a conflict on these before, but we've not had an open case before either on a petitioner.
Right. Okay, so my understanding of the law on that is that if she does not hire an attorney personally, that the county prosecutor is charged with that duty. So if she doesn't, I suppose we would need to have a special prosecutor to pursue the matter. Be my thought on it.
Should we, I don't, is she here today, Your Honor?
She is not here. I don't, is she at the jail, do you know?
I'm not sure. I was gonna say though, I was wondering maybe we could set this out for and show cause her to inquire if she's going to hire an attorney, because maybe whoever she has for her criminal case, she could get to represent her for this.
What happened? 40.
Okay, thank you. Bye.
She is not at the jail.
She's set, let's see. It looks like she has a court date on May 4th for her probable cause. So she'll at least, assuming she shows up, will be in district court on the 4th. And the public defender's office is representing her on that.
Oh.
That complicates things rather than makes it easier.
Yeah. Well, that's why I wanted to bring it to the attention of the court now.
I appreciate that. Okay, what I'm going to do with this, I'll continue the not guilty plea for Mr. Novak, and I'm going to set this for a status conference while the attorney situation gets figured out. Let's set that for May 13th at 8:15. And hopefully the prosecutor's office and the public defender's office can get figured out what needs to be figured out with respect to representation in this case, because it's unfortunately complicated.
Thank you, Your Honor.
So Mr. Novak, your next date is May 13th at 8:15. You can come to in person as you did today, or you can come attend by Zoom if you want the Zoom information available. That's that for you. Okay.
Thanks. Thank you.
We're all set for today.
Thank you.
Okay, Mr. Murphy, are you ready to proceed, Mr. Vaughn?
Yes, Your Honor.
Can you call the June? This is file 26-22527-FHO versus Michael William Vaughn. We are here today for a pretrial conference in this case, and we're proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Vaughn.
And sir, you are Michael William Vaughn.
That's correct, Your Honor.
Mr. Murphy, where do we stand with Mr. Vaughn's case today?
Your Honor, I've retained an expert in this matter. Mr. Corrado has been provided via Dropbox all the discovery relevant in regards to assessing the case. Mr. Corrado, he's been kind of backed up. He hasn't completed his assessment yet. So I was going to ask, I think that, you know, the motion ultimately will be determinative in this matter. Finding out ultimately from him his complete assessment of it is something I wanted to do before proceeding to trial, to file the motion if it was plausible. So I do apologize that it's not been completed at this point. But I would ask the court if we could do just one more pretrial before setting trial in this matter. I know this has been pending for over 3 months. But again, I do apologize to the expert. I suppose I could have gone to a different expert, but Mr. Corrado is a little bit backed up. He is, I have used him in the past, and I talked to Mr. Vaughn. He did prefer that we retain him. So I do apologize, Your Honor, if the court wanted to set trial. I guess we could set trial to get a definitive end date on this. But again, I do believe before that, it should only take another couple of weeks, 2 weeks or so. I was anticipating talking to Mr. Corrado for it to be completed. So I don't believe that, you know, we need a trial date to get a definitive end date on this. I think it should be figured out soon after that, after motions, you know, again, after Mr. Corrado lets me know what the situation is. So that's a long-winded way of saying I'm asking the court for another pretrial. But if the court was inclined to demand a trial, that we ask for a trial, I think, you know, we could set a one-day trial. It would take a 1 day, but I would ask for a pretrial before that was set. And there was also, once the next date is set, I would ask the court if we could address one issue of bond.
Ms. McClure, is there anything you'd like to add at this point?
I have nothing to add other than I guess I want to make sure Mr. Murphy understands the offer that's outstanding, and I wanted to inquire what the expert was, what he's an expert in.
Mr. Corrado is an expert in the DUI, DRE evaluations. Pretty much also, I mean, he's also an expert. He's been retained as an expert before, not by my office, but he's been used as an expert before in regards to the test and what they can provide, and also the underlying drug tests and what they are. Mr. Corrado worked for 40 years or whatever in the Georgia State Police as a DUI training expert. I can provide you his CV if you want. I thought we had a case before that I used, Mom. I guess that probably wasn't you, Ms. McClure, but yeah, I can provide you with his CV if you want. So.
Okay, sounds good. And the offer that is outstanding at this point is to plead to count 1, possession of meth under 7411, and then count 4, the OWI as charged.
Thank you. I believe that's what, it has been that offer for a while, right, Ms. McClure?
Correct.
So I thought I discussed that with my client, so he is understanding the offer at this point.
All right, I will adjourn this out to May 20th at 8:15 a.m. Mr. Murphy, review stipulation and order for that. Adjournment, please.
Yes, Your Honor. For May 20th?
Correct.
Or 8:15 a.m.
You wanted to address bond.
Your Honor, there was one thing I was asking the court to consider is, I understand that there has been a violation of the, or an allegation of violation of the tether, of alcohol testing on the tether. I was asking the court to consider in regards to the drug testing. I don't believe Mr. Vaughn has tested positive in regards to drug testing. He was asking the court to consider placing him on just random testing, not once a week as he is right now, but just regular and random, or I'm not sure how it's phrased, but just if it's suspicion or reasonable suspicion of drug use to be tested, or if he's at the courthouse. But right now he's asking the court to consider not having it once a week, just because of the logistics of it. It is causing him to, I guess, have to drive out from Chelsea. From Chelsea to here once a week. We're just causing him, he has to, take a whole day to do it. Again, he just has to court to consider that. I'm not asking the court to consider removing the alcohol conditions or changing those in any way, shape, or form. Just the drug testing. I don't know if it would make sense. I mean, obviously, it would help his logistical or his transportation situation if there was a day that he knew the testing, but I guess that would defeat the whole purpose, Your Honor. So I think, obviously, if a person knows when they're going to be tested, that causes some issue as to whether or not it's actually being effective. But I don't think, again, he's tested positive or violated the conditions in regards to any drug, just the alcohol back in, I believe that was early February. So he has to go to consider that. If not, obviously, he'll continue to abide by the orders of the court.
Ms. McClure.
I guess I would defer to Mr. Coast on when his last violations were.
Judge, I just checked his drug screen log. His last 9 drug screens have been completely negative, which is good. The main issue, it looks like, is the alcohol. He did have a positive back in January. So I wouldn't be opposed to reducing the drug testing to random where I'd call him in. But I would like to keep him on that scram unit.
I would agree with that, Your Honor.
Based on that, then I will modify the bond conditions so that the drug testing provision is a random drug testing provision. So just when Mr. Coast calls him in.
Thank you, Your Honor. You understand that, Mr. Vaughn?
Yes, I believe so. I'll ask you any questions later if I have any.
Yeah, give my office a call later this afternoon and we can talk more about that and we can clarify with Mr. Coast if there's any questions.
Of course, sounds good.
Anything else we need to address today then, Mr. Murphy?
Nothing further from the defense, Your Honor. Thank you.
Okay, Mr. Vaughn, you can go ahead and log out. Your next date's May 20th. You can log back in using all the same Zoom information that you used.
All right, thank you, Your Honor.
Thank you, Your Honor.
Your Honor, we did provide the court with the advice of rights from Mr. Bauer.
Yeah, I will get there as quickly as I can.
Thank you.
The gentleman at the jail, you are Mr. Hollingsworth?
Yes, sir.
This is file 11-36624-DM, Mark Russell Hollingsworth versus Danielle Lynette Yielding. We are here today for arraignment on a bench warrant for a failure to appear at a show cause hearing. The show cause hearing was related to non-payment of child support. Sir, you are Mark Russell Hollingsworth, correct?
Yes, Your Honor.
Mr. Hollingsworth, have you received a copy of the bench warrant?
I'm not sure. I know that when I opened my mail late, my neighbor was out of town. We must have a substitute.
Slow down, Mr. Hollingsworth. The bench warrant would have been given to you at the jail, not in the mail.
Oh, no.
Okay, we will contact the jail and have them bring you a copy of that. You've already sent it over there. She has it. The bench warrant was again for a failure to appear back on April 8 of 2026.
April 6th, Your Honor. Sorry.
April 6th of 2026. The underlying show cause is related to non-payment of child support. According to the friend of the court information I have, you have a monthly child support charge of $324, and there is currently an arrearage in the amount of $3,457.76. Do you understand, Mr. Hollingsworth, that it is a crime to fail to pay child support to the best of your ability up to the amount ordered?
Yes,
Do you
when I was working at
understand? Mr. Hollingsworth, I need you to just hold off. I'm gonna ask you some questions. I have to make a record that you understand what your rights are before you say anything, because anything you do say could be used against you.
Okay.
Do you understand that it's a crime to fail to appear in court when you've been ordered to appear?
Yes.
Do you understand that if you were to plead guilty or be found guilty of either of those offenses, the court could sentence you to jail for up to 30 days?
Yes.
You are entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. You understand that?
Yes.
You are entitled to be represented by an attorney at this hearing today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that, and I'll appoint one for you from the public defender's office. Do you understand that?
Yes.
Would you like to be represented by an attorney?
Sure.
Do you have the ability to pay for your own attorney?
Oh, I don't.
Okay, I will appoint the public defender's office for you and put you in a breakout session with Ms. Underwood from the public defender's office right now.
Okay.
All right, Mr. Noe, are you ready to proceed with Mr. Bauer?
We certainly are.
All right, Mr. Bauer, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Do.
I'm sorry, I wasn't able to hear you.
I do.
Okay, and you are Devin Michael Bauer?
Yes, I am.
Bauer, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, aggravated possession of child sexually abusive material?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $50,000 fine?
Yes.
Is it also your intention to plead guilty today to count 7, using a computer to commit a crime, maximum imprisonment of 10 years or more, but less than 20 years?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $10,000 fine?
Yes.
Are you satisfied with Mr. Noe and the advice that he's given you?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Ms. McClure?
That's correct, Your Honor.
Mr. Noe?
Yes, Your Honor.
Is that also your understanding, Mr. Bauer?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Bauer, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about August 14, 2024 through January 14, 2025 in Adrian Township, Lenawee County, Michigan, that you did commit the offense of aggravated possession of child sexually abusive material?
You say guilty.
Guilty, Your Honor.
And how do you wish to plead to the charge that, again, on August 14, 2024 through January 14, 2025 in Adrian Township, Lenawee County, Michigan, they did commit the offense of using a computer to commit a crime with a maximum imprisonment of 10 years or more, but less than 20 years?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the board on the record this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Bauer to plead guilty today?
None, Your Honor.
No, Your Honor.
Mr. Bauer, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record today?
I didn't hear the question, Your Honor.
Has Mr. Noe promised you any particular sentence or estimated what your sentence would be other than as we've talked about it on the record this morning?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Noe, do you want to establish a factual basis?
I certainly can, Your Honor. Mr. Bauer, you live in Lenawee County in the state of Michigan, correct?
That's correct.
And would you agree that you have several different devices, computers, tablets, and things like that? Do you have computers at your home?
No.
You have tablets. Did you at the time have computers at your home?
Time, yes.
Okay, at the time. Thank you. And would you agree that you did knowingly possess some child sexually abusive material? Would you agree with that, sir?
Yes.
Would you agree that that involved a prepubescent person or child at that time?
Yes.
In addition to that, would you agree that you used a computer to do that? Was it a desktop or a laptop or something?
Yes.
And I think that's enough at that point. Thank you.
Well, the date range.
Oh, the date range. Yes, I'm sorry. Was that on or about between November 21st, 2024 through January 14th, 2025?
Yes.
Okay, thank you.
People are satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Noe?
It has.
I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Bauer has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as it's been discussed on the record this morning. I will refer this matter to probation department for a pre-sentence investigation and set sentencing for June 5th at 8:15 a.m. And that sentencing will be in person.
I do, Judge, have, excuse me, 2 other sentencings with Judge Olsaver that morning at 8:15. I'm sorry, Judge Shadler, sorry, at 8:15. Then I also have a bench trial with this court. Would it be possible to go to the 12th? I'm not available. I guess we can do the 5th as long as the court would be patient with me so I can take care of my issues in district court first. Just so the court knows that. I will be running a little bit behind. I won't be there right at 8:15.
All right, that will be fine.
Okay, I just wanted to let the court know, just I will be late, but it's because I'm doing that as well. All right, that sounds good enough, son. Thank you.
All right, anything else we need to address on this case today then?
Just to put on record that the trial dates are vacated. Otherwise, nothing on behalf of the people.
I would agree.
Thank you. Ms. Bauer, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Understood, Your Honor.
I am going to put you in a breakout session with Mr. Moore from the probation office, and he's going to collect some of your contact information and give you some instructions on what you're going to need to do next.
You can join another Devin.
Okay, we are back on the record in file 11-36624-PM. Mark Russell Hollingsworth versus Danielle Lynette Yielding. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Hollingsworth this morning, Your Honor.
And you know how Mr. Hollingsworth would like to proceed?
We would ask the court to enter a not guilty plea on Mr. Hollingsworth's behalf, Your Honor. Mr. Hollingsworth is currently working and fully employed through Elwood Staffing in Hillsdale, Your Honor, through which is a temp agency, through which he is working at, I'm sorry, what is the factory in Jonesville, Mr. Hollingsworth?
It's called Ultra Fit.
Also, Ultra Fit?
Ultra Fit, yes.
Ultra Fit, Your Honor, and working full time for them. So we would ask for a PR bond in this matter and a brief adjournment so that Mr. Hollingsworth, if he works enough hours, this job will become permanent, I believe, Your Honor. So we would ask the court to release him with a short date, and when I believe, have you received a paycheck yet, Mr. Hollingsworth?
Yes.
Okay, your next paycheck, will you make a payment out of that? When do you receive it?
I get paid weekly, so I should get paid next Wednesday.
Next Wednesday?
Yes.
He would be glad to make a payment, Your Honor, and if we could set this for an upcoming Monday.
All right, I will enter not guilty plea for Mr. Hollingsworth. I'll set this for a hearing on May 18th at 8 a.m. I will issue a PR bond for Mr. Hollingsworth. Mr. Hollingsworth, you need to come as soon as you're released from the jail. You need to come over to the courthouse, down to the bottom floor, and talk to the front of the court to make sure that they have your contact information and your employer's information.
Okay, absolutely.
All right, and again, your next date is May 18th at 8 a.m.
Thank you, Your Honor.
Thank you. Will I get a copy of that as well?
If you go to the front of the court and make sure that they have your correct address, you will get a copy in the mail.
Okay.
All right, so you're all set for today.
All right, so am I able to go, or I gotta stay here? I mean, after I go to the court, after I go to the front of the court, do I get to go home, or do I gotta come back here?
You can go home.
Okay, thank you so much.
All right, you can let them know that you're done with court.
Okay, thank you.
Mr. Murphy, are you ready to proceed with Mr. Bennett?
Your Honor, could I have a breakout with him? There was a communication yesterday between myself and the prosecutor's office I haven't been able to talk with him about.
Okay. So, Mr. Fry, I believe Ms. Bowles is here in the courtroom. Are you going to need to speak to her?
No, Your Honor.
Okay, Ms. Bowles, you can come forward and stand at the podium, please. This is file 25-22488-FH, People versus Heather K. Bowles. We are here today for a pretrial conference in this case, and we're proceeding by video, partially by video conference and partially in person. First, can you have the attorneys place their appearances on the record?
Phoebe McClure, may I have the people?
Brian Fry on behalf of Heather Bowles.
And Miss, you are Heather K. Bowles?
Yes, Your Honor.
All right, Mr. Fry, where do things stand with Ms. Bowles' case today?
Yes, Your Honor. I am in the process of working on a motion in this case, but we wouldn't be imposed for the court to schedule it for trial and get us a trial date either, if that's what the court wants to do.
All right, Ms. McClure, anything that you need to address?
No, Your Honor.
Mr. Fry, what kind of motion are you filing and how long do you expect it to take to get that filed?
It'll be a motion to quash, Your Honor, and probably 2 weeks to file it.
I am not seeing that we have a copy of the pre-exam transcript yet. I don't know if you have it, Mr. Fry.
I did receive it, yep.
Okay,
That was
could you
filed
provide
before-
us with a copy? Oh, I'm sorry.
No, that's fine. I was just going to say it was filed with the court on March 3rd.
Okay, for some reason, our office does not have a copy of that. Could, I guess, either the court or Mr. Fry provide a copy to the people?
Yeah, I can forward it to you. That's not a problem.
Okay.
Okay, I'm going to adjourn this to May 20th then at 8:15. So Ms. Bowles, your next date again is May 20th at 8:15. You can attend in person like you did today, or if you prefer to attend by Zoom, the bailiff has Zoom information. You can attend that way too.
Thank you, Your Honor.
You were all set for today then. Mr. Fry, can you do a stipulation in order for you?
Yep, I can do that. Ms. McClure, could I sign your name with permission?
Could you actually send that to Mr. Sneed and have him sign that?
Okay.
Just because he, I don't know, at his request.
That's fine.
Okay, thank you.
Well, I guess if it's not a stipulation, then, I mean,
It is a stipulation. He just wants to sign it.
okay. I'll prepare that then. Thank you.
Thank you. I just admitted someone to the meeting whose screen name is just iPhone. Need you to start your video and unmute your device.
Yes, Maurice Jones.
Okay, Ms. Underwood, do you need to speak to Mr. Jones?
Yes, Your Honor.
Okay, this is file 25-22432-FH and 26-22548-FH, People versus Jeffrey Lee Bennett. We are here today for a pretrial in both of those cases. There's also a pending contempt in the case ending 432. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Bennett.
And Mr. Murphy, where do we stand with Mr. Bennett's cases today?
Your Honor, the communication I had with the prosecuting attorneys yesterday, from my understanding, in place to my understanding of the offer at this point on the record, I discussed it with my client. The offer will be for Mr. Bennett to plead in 22432, trafficking while intoxicated, third offense with a second habitual offender notice. And then in file 22548 FH, Mr. Bennett would, the offer would be for him to plead to an aggravated domestic violence second offense, which my understanding is a 5-year felony. That's the extent of the agreement. Anything, there'll be no sentencing agreement. That will be up for argument at sentencing in front of Your Honor. At this point, again, am I correct on that, Ms. McClure? That's the offer?
That is correct.
Great, thank you. And at this point, again, that's what I discussed with my client. She does not wish to accept that offer at this point. So I think the cases are continuing. I think the 22548 FH, is that already set for trial?
It is. It's set September 1st and 2nd.
So I guess at this point, we're just asking to continue the cases along, in regards to that. And I mean, I guess the operable and intoxicated, if we could set, you know, a pretrial on the same date as the final pretrial on that file, which I believe is, August 26th. If there's some resolution between now and then, I mean, I'm gonna keep talking with my client and with the prosecutor. If there's some resolution on the files, I'll communicate with the court and come before then, but I guess at this point, I don't see a necessity to come back with that file either. Okay, so.
All right, then we'll set a pretrial in the 25-22432 FH case for August 26th at 8:15 a.m. That is the date of the final pretrial in the 22548 case.
Thank you, Alan. I'll do the stipulation order on that 22432 file. Is that right number? That's well, you know what I mean.
Yeah. Right. Mr. Bennett, you can let the officer with you know that you're done with court for today then.
Okay, thank you. Mr. Murphy, could you come see me when you get a chance?
Yeah, I'll come tomorrow. I'll come in person tomorrow to talk to you, okay?
All right, thank you.
It'll probably be late morning, okay?
All right, thanks.
Thank you, Your Honor.
Okay, Ms. Underwood, are you ready to proceed with Mr. Jones?
Yes, Your Honor, thank you.
This is file 23-21615-FH and 23-21616-FH, People versus Maurice Leroy Jones. We are here today for a hearing on a violation of probation, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Rhonda Underwood for Mr. Jones this morning, Your Honor.
And sir, you are Maurice Leroy Jones, correct?
Yes.
All right, Ms. Underwood, where do we stand with Mr. Jones's cases today?
Your Honor, there are some things I want to check out. I know for certain that Mr. Jones has showed me a medical marijuana card that is valid, Your Honor. So there are just some things I want to check out. So I would ask for an evidentiary hearing time, Your Honor, and that the not guilty be extended.
Okay, Ms. Arnold, is there anything that the people need to address?
Judge, I'm not sure what the nature of the violation allegations are, but we do, just so Ms. Underwood and Mr. Jones know, we do have a pending drunk driving warrant request that we're waiting for blood results on. So I don't know if Ms. Underwood would prefer to wait for that or
Yes,
go ahead and set
perhaps
the
we
hearing.
should, Your Honor.
Pardon?
I'm sorry, Ms. Arnold.
I didn't know if we want to wait for those blood results before we adjudicate this, or if we want to go ahead and set it for a hearing.
Your Honor, I think Ms. Arnold is correct. Perhaps we should have a pretrial after.
Well, the allegations here don't have anything to do with a drunk driving. The alleged violations are leaving the state of Ohio, admitting marijuana use, and being terminated from his job for non-attendance.
Okay.
So I don't see any reason that we would need to wait indefinitely for his unrelated drunk driving charges to if they come to.
Your Honor, I'm concerned because I believe this drunk driving case may have come out of the contact Mr. Jones had with an officer that day where Mr. Jones made certain statements. And that's why I'm concerned about that, Your Honor.
Judge, I don't think it would be any issue with giving.
Well, there is. I'm sorry.
Sorry, Judge. I was just going to suggest we can give Miss Underwood those reports if the allegation isn't related to drinking on that particular date and time, then I don't think the blood results would be relevant. I just wasn't sure what the alleged violation was.
Thank you.
Well, as I read the file, these don't look to me things that would be admitted during a traffic stop with the officer. I mean, they're talking about just losing employment at KFC. I mean, if that did become a topic of conversation during his traffic stop, then
That's right.
I don't know. I think you'd have a point, but it doesn't appear to me that that's the case. It appears to me from the allegation that he admitted these things to his probation officer. And so I'm going to set it for a hearing. If it turns out to be the other way around, we can adjourn that hearing. But
thank you, Your Honor.
we need to move forward on these and not let them linger indefinitely. So, Ms. Clark, can you give us a 1 hour hearing date for a probation violation?
Tuesday, May 19th at 2:30.
Judge, I'm not here on the 19th. I'm out of town between the 12th and the 19th, and then I'm back.
May 27th at 2:30.
Is that Memorial Day? Oh, no, it's not. Wait, sorry. I was looking at April. 27th at 2:30. That's good.
Thank you.
Okay, so May 27th at 2:30 p.m. That's an evidentiary hearing, so that will be in person.
Thank you, Your Honor.
Thanks, Judge.
All right, Mr. Jones, you understand you need to be here in person on May 27th?
Yes, Your Honor.
Okay, you're all set, then you can go ahead and log out.
Thank you.
I believe that's my docket with you this morning, Your Honor.
Okay, thank you, Ms. Underwood. Mr. Murphy, are you ready to proceed with Mr. Allen?
Yes, Your Honor.
Is file 25-22467-FH, People versus Robert D. Allen. We are here today for an arraignment on a warrant for alleged contempt of court for violating bond conditions. We are proceeding today in person. Sir, you are Robert D. Allen?
Yes, I am, sir.
Mr. Allen, have you received a copy of the bench warrant?
No, sir, I was just told to turn myself in this morning and I did.
All right, we will get a copy of that for you in just a moment. In the meantime, I will let you know that the warrant alleges that you violated your bond conditions by testing positive for cocaine in a drug screen collected on April 23rd, 2026 at Lenawee Drug and Alcohol Monitoring. That would be considered a contempt of court. The maximum possible punishment for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You have the right to be represented by an attorney. You're obviously represented by Mr. Murphy in the underlying case. You want me to handle this issue for you as well?
Yes, sir.
Mr. Murphy, do you know how Mr. Allen would like to proceed?
Your Honor, in regards to this matter, I'll just ask the court to enter a not guilty plea at this time and set this for the same date as his sentencing. What's that? May 28th, I believe. Obviously I didn't have this on my docket. Mr. Allen informed me of this morning, asking what was going to happen. Now, Mr. Allen is currently working. His big concern here, that's why I'm asking for this to be set for the 28th. I want to talk to Mr. Coast about this, about the testing, and it sounds like I have some issues with the actual testing procedures as well as, I guess, I guess I'll leave it at that. But I would ask the court to give him a PR bond. I understand, obviously, with violations of bond conditions, the court would have a question or concern about, Mr. Allen's continued, I guess you want to say compliance with the court order. But I believe his recovery coach is here. That's why I said the situation, I'm kind of confused by it. I need to talk to Mr. Coast further. I don't believe Mr. Allen is a flight risk. Obviously, he turned himself in as soon as he was told to. He's available for testing right now. If your honor wants to test him to show that he's clean right now before you were to be releasing him into the public or into the community. But I got to ask the court to consider a PR bond. He is, I think how many more days until you're full time?
54 more days.
So at his job, 54 more days and be hired full time in there. That's what he's hoping to accomplish here. Moving forward, obviously with the sentencing looming before him. But in regards to this, I'd ask the court to consider again if you want to test him today, and based upon that, give him a PR bond or whatever. But I'd ask the court to consider that.
Judge, I'm just a little concerned on this. He did test positive back on March 4th for cocaine. We actually sent that sample out to where it was confirmed positive. He pled not guilty to that contempt. We're supposed to have a hearing on it April 21st. Pled to that contempt, and we put the sentencing over to his original sentencing, which is May 8th. And then 2 days later, he's tested positive again for cocaine.
All right, are you able to test him right now, Mr. Coast?
I could, Judge.
Okay, let's do that. Letter not guilty plea, I'll hold off on the bond decision until I know the results of the test. So if you'll step out in the hallway, Mr. Coast, will be right out to see.
Thank you, Your Honor.
Okay, the gentleman at the jail, what is your name?
Giroux, Richard.
Okay, Mr. Malero. Do you need to speak to Mr. Giroux?
I do not believe so, Your Honor.
All right. This is file 22-20936-FH, 25-22330-FH, 25-22331-FH, 26-22529-FH, 26-22543-FH, and 26-22581-FH. People versus Richard James Giroux Jr. We are here today in the 25 case for in the 22 case for probation violation. In the other cases for a pretrial conference, as well as hearing on various contempts that are pending. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Salvatore Malero on behalf of Richard Giroux.
And sir, you are Richard James Giroux Jr., correct?
Yes.
Mr. Malero, where do we stand with Mr. Giroux's cases today?
Your Honor, yesterday, I believe we sent over to the court a signed plea agreement and the corresponding advice of rights. The plea agreement with respect to all of the pending felonies are as follows. Mr. Giroux will plead guilty to count 1, possession of methamphetamine in the 330 FH, 331 FH, 529 FH files. There is an agreement that the habitual offender fourth notices and the 581 FH, 543 FH files will be dismissed at sentencing. There is no sentence agreement. Ms. McClure has estimated a guideline range of 19 to 38. We are not agreeing or disagreeing with that. We would do our own assessment of the sentencing guidelines and file a memo if necessary and argue at allocution. I believe that is the extent of the plea agreement for the pending felonies. And Mr. Garreau will be pleading guilty to the probation violations.
All right, Mr. Garreau, will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Richard James Garreau Jr., correct?
Yes,
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty and file 22529-FH to count 1, possession of methamphetamine?
yes,
Do you understand the maximum possible penalty for that offense up to 10 years in prison and or a $15,000 fine?
yes,
Is your intention to plead guilty also and file 25-22331-FH to count 1, again, possession of methamphetamine?
yes,
You understand that also carries maximum punishment of up to 10 years in prison and or a $15,000 fine?
yes, I do.
And is it your intention to plead guilty also and file 25-22330-FH to count 1, possession of methamphetamine?
Yes, I do.
And again, that has a maximum possible penalty of 10 years in prison and or a $15,000 fine. You understand that?
Yes, I do.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yes,
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct, Your Honor. And just for the record, the only reason I put the estimated guidelines on the plea form was because we had discussed that. So I just wanted to make sure that that was on there, but it's not any sort of Kilbrew or anything like that.
Okay. Is that correct, Mr. Malero?
Yes, that is correct, Judge.
Is that also your understanding, Mr. Yarrow?
yes,
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Garreau, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
yes,
You also understand that any appeal from the conviction and sentence pursuant to your plea will be by application for leave to appeal and not by right.
yes,
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
no, I don't.
Do you understand that you're giving them up?
Yes,
How do you wish to plead in file 25-22330 FH that on or about March 16, 2025 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of methamphetamine?
Guilty.
And how do you wish to plead in file 25-22331-FH to the charge that on or about July 4, 2025 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of methamphetamine?
Guilty.
And how do you wish to plead in file 26-22529-FH that on or about December 17, 2025 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of methamphetamine?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it
Yeah.
was not your choice to enter those pleas?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Garrow to plead guilty today?
None, Your Honor.
No, Judge.
Mr. Garrow, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court's not bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding, failing to appear at sentencing, and violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
Mr. Malero, do you want to establish the factual basis?
Yes, Your Honor, but as a point of clarification, the prosecutor has estimated the sentence, but I think it's been made clear that it is not a Killebrew agreement or a Cobb's agreement or any sentence that the defense has agreed to.
Understood. She's estimated the sentencing guidelines.
Correct.
Yep.
So, Your Honor, or Mr. Garreau, as to the 529 FH file, is it true that on or about December 17th, 2025, you were in the city of Adrian, County of Lenawee, State of Michigan?
Yes.
And at that time, did you knowingly and intentionally possess a controlled substance known as methamphetamine?
Yes.
And you were not, you did not have any legal justification for possession of that, of the methamphetamine?
No.
And you, in fact, you knew it was illegal.
Yes.
Okay, and that was due to your addiction to methamphetamine?
Yes.
All right. Is the court and the state satisfied as to that file?
Yes, Your Honor.
Yes.
All right. Mr. Garreau, as to the 330 FH file, is it true that on or about March 16th in 2025 in the city of Adrian, County of Lenawee, State of Michigan, you were in possession and knowingly and intentionally possessed the controlled substance known as methamphetamine?
Yes.
And you knew that it was illegal to possess that substance?
Yes.
And you did not have any legal justification to be in possession of that substance?
No.
Is the court and state satisfied as to that file?
People are satisfied.
Yes, sir.
And Mr. Garreau, as to the 331 FH file, last but not least, on or about July 4th, 2025, in the city of Adrian, County of Lenawee, State of Michigan, did you knowingly and intentionally possess the controlled substance known as methamphetamine?
Yes.
In fact, you knew it was methamphetamine?
Yes.
And you knew that it was illegal to possess such a drug?
Yes.
And you did not have any legal justification to possess that substance?
No.
Is the court and state satisfied as to that offense?
People are satisfied.
Yes. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
I believe the court has, Your Honor.
All right, I will accept those pleas then. They have been given understandably, voluntarily, and accurately. Mr. Garrow has had full knowledge of his rights and has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department and set sentencing for June 5th at 8:15 a.m.
Do we need to address the probation violations?
Yes, we do. Thank you.
Judge, I'm not available on the 5th of June.
Okay, how about June 11th at 8:15?
That would be fine.
Okay, Mr. Garrow, in file 22-20936-FH, do you understand that you have a right to contest the violation of probation charges and to have trials on those?
Yes.
Do you understand that, again, throughout that trial, you'll be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
Again, you have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes.
Again, you're not required to testify. No one can say anything about you not testifying or hold that against you. But you also have the right to testify if you wanted to testify. Do you understand that?
Yes.
How do you plead to the charge that you violated your probation in the 22-20936 file?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anyone threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you're giving up any and all claims that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
You were placed on probation back in December 2022. Is that correct?
Yes.
And as part of that probation, you were required to obey all laws and all court orders. Is that correct?
Correct.
And while you were on probation, you were charged in these other files. Is that also correct?
Yes.
And in these other 25 and 26 files, you were required to do drug testing. Is that correct?
Correct.
And did you fail to test on August 14, 2025?
Yeah, probably, yes.
Did you also fail to test on August 19, 2025?
Yes.
Did you also fail to test on August 21st, 2025?
Yes.
And on August 28, 2025?
Yes.
And also, let's see, there's 3 more dates, August 30th, September 3rd. I'm sorry, just August 30th and September 3rd. Did you also fail to test on those dates?
Yes.
Oh, I'm sorry, on September 3rd, the allegation was that you actually tested positive. Did you test positive on September 3rd?
Yes.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Garreau has had full knowledge of his rights, had competent counsel. I will refer this matter to the probation department as well and set sentencing for the same June 11th date. Mr. Garreau, someone from probation is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay.
Is there anything else we need to address today, Ms. McClure or Mr. Malero?
I do not
No,
believe
Your
so.
Honor.
Mr. Garreau, you can let the officer with you know that you're done with court for today.
Thank you, Judge. I believe that's all I have with your court, Your Honor.
Okay, thank you, Mr. Malero. Have a nice
Have a
day.
good day. Yep.
Mr. Coast, do you have the results back from Mr. Allen? You are talking and muted, Mr.
I apologize. He did test and he tested positive for only THC.
All right. Okay, so we're back on the record in file 25-22467-FH, People of State of Michigan versus Robert D. Allen. We do have the results of his drug test back, and as Mr. Coast just indicated, he only tested positive for THC. Coast, does he have, is there a prohibition on marijuana, or does he have a medical marijuana card? Where do we stand?
Judge, he has presented me with a card, so he's okay with that positive.
All right. All right, so there is obviously still the pending violation. In this case, there was a plea agreement to no upfront jail. Given that, I would like to have this matter resolved before the sentencing date, because that obviously has an impact on what the sentence may be. So, Ms. Clark, could I have a 1 hour date for a bond violation hearing?
Yes. You want that before May 8th?
Thought it was the 28th.
28th.
May. I thought it was May 8th.
It was May 8th.
On my paperwork, I had.
Yeah, I'm sorry, it's May 8th. I said 28th, I'm sorry.
Oh, I'm sorry. Do we have any available dates before May 8th?
No. No, we do not. Next available will be May 12th at 3 o'clock.
All right, we'll set it for May 12th at 3 p.m. then. And I would like to adjourn the sentencing to that date as well after the hearing's been conducted.
Yes, Your Honor.
So
And
May
Robert, if you
12th.
wanted that sample sent to the lab, you're gonna have to get with the center.
To where I drop that?
Yes,
Correct.
where you drop it.
Oh,
So May 12th at 3 p.m. then. I will issue a PR bond for Mr. Allen. Mr. Allen, what you need to understand is that you're going to have to continue to test. There's another positive test, there's going to be another warrant, and there's not going to be a PR bond if there's a next time.
Is there any way I can do like every 48 hours testing or something? Like I really want to prove, like I don't know what's going on. I want to prove you guys.
Yeah, you know, and I apologize, I didn't request it, but yeah, again, Mr. Allen was asking if there could be an increased regimen of testing, to show, his compliance. Again, that's why you know, in regards to the incident itself, I want to talk to Mr. Coast, but, he was asking for an increased regimen, maybe to, you know, if the court wanted to.
Mr. Coast, what are your thoughts on increasing the frequency of testing?
Judge, right now his color is green, so he's testing 2 times a week. I can up that to 3 times a week, which is the color brown, which I could switch that immediately if you'd like.
All right, I guess then based on the request of Mr. Allen, we will do that.
Thank you, Your Honor.
So Robert, you're going to start calling tomorrow morning, and if brown is called, then you need to go. And I'll let the center know that that's your new color.
Okay, thank you.
All right, anything else we need to address today?
Nothing from the defense, Your Honor.
Okay, thank you. Mr. Murphy, you ready to proceed with Mr. Spesser?
Yes, Your Honor.
Judge, I just wanted to give you a heads up for Mr. Owen. Mr. Sneed wanted to be present for that. So when you're ready to call it, if you want to give me a 5-minute heads up, I can let him know.
Okay, you can probably let him know right now.
Okay.
Thank you. All right, this is file 26-22520-FH People versus Joseph Paul Abraham Spesser. We are here today for a pretrial conference and we're proceeding by proceeding person. First, well, partially in person and partially by video conference. I think Ms. McClure is just notifying Mr. Sneed, so as soon as she gets turned back on.
I'm sorry, I apologize for interrupting, Your Honor. I had this down as there's a show cause. I think he has sentencing on, this is where I got the May 28th date in my head. I think he has sentencing already on the underlines for May 28th, and this is a lingering, or is an allegation of bond violation, if I'm not incorrect.
Okay, you are correct, I apologize. So.
Yes, sir.
Sir, you are Joseph Paul Abraham Spesser?
Yes, Your Honor.
Mr. Spesser, you received a copy of the warrant?
Mr. Coast had sent me a letter. I didn't know there was a warrant. It didn't say anything about it.
I'm sorry, it's not a warrant. It's an order to show cause.
Yes, sir.
You got that. All right, so that order to show cause alleges that you violated your bond conditions by testing positive for THC, amphetamines, and methamphetamine drug screen collected on April 13th, 2026 at Lenawee Drug and Alcohol Monitoring. That would be a contempt of court. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You're entitled to be represented by an attorney today. Obviously, Mr. Murphy represents you already on the underlying case. Do you want me to represent you on this as well? Mr. Murphy, do you know how Mr. Spesser wants to proceed today?
Your Honor, at this time, I was just going to ask if we could, I mean, I guess ultimately, the same issue I have with Mr. Allen was the same with this one. I have questions about possible, and testing procedures. I want to talk to Mr. Coast about his understanding of what's been occurring at the testing, facility. I was asked if we could set this. I think ultimately, Mr. Spesser isn't, he would ask this to be set for the 28th of May with his sentencing. I don't think we're gonna have a hearing on this. I just want to get some clarification. Ultimately, Mr. Spesser just tested yesterday. I believe he tested clean. He can test today. Again, Your Honor, he'll show that he's clean again today. I'd ask the court to enter a not guilty plea and set a PR bond on this. If Your Honor wants to do a hearing before the 28th, I guess that's understandable. But I don't believe that there was, I don't believe we're going to ultimately go forward with a full hearing after I get some understanding of some things. I just wanted to inform the court of that, if that makes sense. But I guess at that point, what I'm asking the court to consider is just enter a not guilty plea and give him a PR bond at this point until the 28th. Again, I believe that he hasn't tested negative yesterday. I believe he would test negative again, or test negative again today if he tested him.
Judge, he did test yesterday at the center and he was positive for THC.
Yeah, and Your Honor, he does have medical issues. He has a liver issue right now. One of the other things, that's why, in regards to the testing positive, it's possible that there's some medical issues releasing from prior use that's that could be stored in his system. Obviously, the THC, I think he had been given some time to be clean on that. I don't know if the THC is considered a violation of his bond conditions. But I also believe that he had medical reasons that he could be using the marijuana as well. If he didn't have a card, he could probably get one if he went through the process for that. But again, ultimately, in assessing the situation, I think I have some questions about that. Again, the health issue he has, those things contributing to possibly the positive test. Also, what will happen if he is found guilty of the violation? Because again, my hope is that Mr. Spesser continue along the path he's on right now. When sentencing comes along and the court would allow him to be on probation. So in regards to this allegation, obviously Mr. Spesser would ultimately, I think, not want to fight the test at a hearing if it was a situation where he was going to be placed on, again, given a fine, a suspended sentence on his probation that he would hopefully get moving forward. I guess I've bled into my, what we consider allocution for the sentencing. I didn't mean to do that. But again, Your Honor, Mr. Spesser, I believe he's gonna, be clean today with other than THC. Again, if that's a violation, I wasn't aware of that. I do apologize for that. I do believe that he isn't trying to use any illicit drugs to, obviously there's a difference between using methamphetamine and using marijuana in regards to medical purpose for it.
Well, there's a letter in the file from Mr. Coase dating back to April 8th that indicates this issue of marijuana was discussed with Mr. Spesser, and he was told that he can't be using marijuana at that time.
Again, Your Honor, so that this is
not providing a valid card, and Mr. Coase has not provided a valid card.
He is not, Judge. I did submit a letter dated April 27th. He did admit to use of marijuana on April 1st. I was giving him a month to clean out his system. So we're 29 days after his last use, so he should start testing negative, and that's correct. He has not provided me with the medical marijuana card.
And that's what I was trying to explain, Your Honor. Again, if he stopped using on April 1st marijuana, it could still be in his system for 30 plus some days. I guess testing yesterday and testing today would almost be the same effectiveness. I was, obviously my anticipation would be that once 30 plus days has occurred, so next week, definitively no marijuana unless, again, he gets a medical marijuana card, presents it. But I think he's aware that he can't use marijuana.
Should be clean either way because he hasn't, you get to 30 days, right? Because he hasn't produced a card, so he should not have been using it since the 1st.
Yes, Your Honor. I mean, yes.
Your Honor, all I really know about my liver, I just went to see a liver specialist last Friday, and all they keep telling me is I have a fatty liver. From what I'm aware with drugs in the system, they claim the fat cells. from what I talked to the doctor, as it's healing, it could be releasing a lot of toxins that have been in my system. I mean, I'm not saying for sure that's what it is. Also, when I was down in Toledo for this appointment, my driver's license is suspended and it had expired. So when I went to renew it to try to just get an ID, they told me I had to have a birth certificate, Gordon, Ohio. So I went down there to get a birth certificate, but their system was down. They said they could mail it. I mean, that's going to take weeks. So I have to get a valid ID before I can get my medical card. And between being in jail at the beginning of this year and being in the hospital for a week and a half, it's taking time. And you know, I've been trying. It's not like I haven't been trying to. I understand that I need to.
The issue is you don't have one,
Correct.
so you can't use marijuana.
Correct.
All right, I will enter not guilty plea for Mr. Spesser. I'll set this for May 28th, which is the date of sentencing.
Thank you, Your Honor.
And we will look to see whether those tests start being clean, which they should be.
If I would already have my idea, it would have been taken care of. I just didn't know I had to go through all this stuff too bad.
Is there anything else we need to address today?
Nothing further from the defense, Your Honor. Thank you.
All right, thank you.
Thank you,
Yeah, stop any questions.
Yeah, appreciate it.
All right, this is file 25-22208-FH, People of the State of Michigan versus Daniel Jason Owen. We are here today for a final pretrial conference in this case, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Good morning, Your Honor. Isaac Sneed for the people.
Matthew Murphy appearing on behalf of Mr. Owen.
And the record to reflect this matter was set for a final pretrial conference this morning at 8:15 a.m. It's now 10:11 a.m. Mr. Owen is not present in the courtroom. Mr. Murphy, do you have any information about his location?
Your Honor, as we had, I believe, Mr. Sneed and myself had talked to Your Honor in Your Honor's office last week or so. The information I have, because I just received an email from Mr. Owen yesterday, in which he confirmed that he wanted to accept the people's offer and to have it typed out, written out, the plea offer available. He says that he's in Beaumont Hospital. We relayed to him that we need some documentation. He says he has some medical issues that are being worked on. I have no documentation that we've gotten. And I apologize. I assumed he was going to be zooming in because he has access to be able to email. But I guess that assumption was incorrect. So I do apologize for his absence, Your Honor. It was my anticipation to enter a plea this morning. But his email said that he would like to accept that plea offer and that he has got another week or so, he believes, of medical issues to deal with at Beaumont, and then he'll be turning himself in to Lenawee County Jail once that's done. So that's all the information I have for Your Honor.
So you have some confirmation that he's actually at Beaumont Hospital?
We have not received any documentation from Beaumont. We've just received an email from him. And he hasn't given a definitive location for Beaumont, which is like Pomedica, I guess.
All right. Mr. Sneed, is there anything you would like to address?
Your Honor, I would defer to the court's discretion as to, I believe there already is a warrant in place for Mr. Owen. So in terms of scheduling, I think we should cancel the trial for May 12th, as we had discussed in chambers, and potentially convert the 12th to a pretrial conference, and hopefully Mr. Owen will communicate better with Mr. Murphy in order to complete the plea process.
Yes, John, I'd ask for that as well. I believe there already was a bench warrant put out because the bond was, and it had been made clear to Mr. Owen that after his stay at Linwood Manor, he was supposed to go to the jail. It wasn't okay for him to go anywhere else, Beaumont or either, any place. As such, my understanding was a bench warrant has been issued. He has a warrant for him right now, which I informed him of over email. And as such, I would ask, I would agree with Mr. Sneed. I think that we, given my understanding of Mr. Owen, he wants to take the plea offer. I don't think there's a necessity to have the jury trial continued on. Even if he didn't convey to me any indication of accepting that offer, I have grave concerns about continuing with the 4 or 5 day trial without him being present at this final pretrial. But so I would ask that the trial be taken off. I believe that the case, hopefully, if he doesn't voluntarily turn himself in after his medical treatment, hopefully law enforcement finds him pretty quickly.
Okay, so I will vacate the trial dates. We will convert the May 12 at 9 a.m. First day of the trial to a pretrial conference. Hopefully we'll have some communication with him and get the plea entered on that date. There is the outstanding warrant that Mr. Murphy referenced, so I will let that stand for the time being. And hopefully he will do as indicated and turn himself into the jail once he's released from the hospital, assuming that that's where he is.
Thank you, Your Honor.
Thanks, Ron.
Okay, thank you.
That's all that I had, Your Honor. I'm gonna leave your courtroom now. Thank you.
All right.
You have a good day.
And Mr. Dubin, are you ready to proceed with Mr. Masky? Okay, this is file 26-22547-FH People of State of Michigan versus Joshua Paul Masky. We are here today for a pretrial conference in this case, and we are proceeding today partially in person and partially by video conference. First, I have the attorneys place their appearances on the record, beginning with Ms. McClure.
BB McClure on behalf of the people. The prosecutor of record is Mr. Bennett, if he pops in.
Okay.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Masky, who stands to my left. Please state your name for judge.
Joshua Masky. All right, and Mr. Dubin, where do we stand with Mr. Masky's case today?
Your Honor, I've had ample time to talk to both the prosecutor and my client about this case, Your Honor. We have reached a plea agreement, that plea agreement being a dismissal of count 1. My client would tender a plea of no contest to attempted children accosting and for immoral purpose. My client does understand his rights, does wish to avail himself to that offer here today. And if I may approach, I do have a plea sheet for you as well.
Okay. Has he signed an advice of rights form?
He has, I believe, prior, Your Honor. I have advised him of those rights. If not, I can have him sign another one, of course. Signed by the prosecutor of record as well, which is Alex. So I'd stopped in their office earlier.
Okay. Okay, I don't see an advice rights form in the file, so I'm going to ask him to sign
May I approach?
Yeah.
Kind of jumped the gun and started approaching before. I apologize.
Fine.
Oh, you want me to, sorry. Yeah, I approach, Your Honor.
Okay, record should reflect I do have a signed advice of rights form. I am placing that in the file. Mr. Masky, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Joshua Paul Masky?
Yes, Your Honor.
Mr. Masky, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to attempted accosting a child for immoral purposes?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes, Your Honor.
Do you understand that that is a tier 2 SORA offense and that will require registration on the Michigan Sex Offender Registry?
Yes, Your Honor.
Are you satisfied with Mr. Dubin and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Dubin?
That's correct.
Is that also your understanding, Mr. Masky?
Yes, Your Honor.
If a plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime could result in deportation, exclusion from admission to the United States of America, or denial of naturalization.
Yes, Your Honor.
Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about August 22nd, 2025 through August 23rd, 2025, City of Hudson, County of Lenawee, State of Michigan, that you did commit the offense of attempted accosting children for immoral purposes?
No contest, Your Honor.
Has anyone made any threats or promises to you to induce you to plead no contest to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Masky to plead no contest today?
No, Your Honor.
And none from the defense, Your Honor.
Mr. Masky, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
There is a sentencing agreement. I would just note that for the record.
Correct. Mr. Masky, do you understand that if your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation? Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead no contest today?
Yes, Your Honor.
And how are we establishing the factual basis?
Your Honor, if I may, the purpose of the no contest plea is lack of recollection. Additionally, I would stipulate to the police report for factual basis, Your Honor.
And Your Honor, I can place that on the record at this time.
Okay, go ahead. Thank you.
The police report number is 25773. It is a Hudson Police Department report that was authored by Chief Ronald Keck, and made a part of that record was a Child Advocacy Center disclosure statement, which was typed by interviewer Amber Cook. And that disclosure statement details in relevant part to this charge that on August 22nd into August 23rd, 2025, on Lane Street in Hudson, Michigan, at a home, that the defendant did approach a 9-year-old child with the initials CJ, and approached her in the living room, attempted to pull her pants off of her, and made a comment, in quotes, "I always wanted to do it to you." The 9-year-old stated it was naughty things that parents did to make babies. The 9-year-old then did run away from the defendant and notified a parent. And I believe that would satisfy the factual basis, Your Honor.
Do you agree with that, Mr. Duke?
Satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Duke?
Absolutely, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Masky has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 5th at 8:15 a.m.
June 5th. Perfect, Your Honor. We appreciate that very much.
All right, Mr. Masky, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, Your Honor.
And if you will step across the hall to the probation department, they will give you a packet of information, some stuff you'll need to fill out, and they'll collect your contact information and give you some instruction on what needs to happen next.
Thank you so much, Your Honor. I appreciate you guys' time. I hope you have a wonderful rest of your day.
Thank you. You too.
See you June
And
5th.
Judge, what was the sentence date? I'm sorry.
June 5th.
Okay, thank you. Sorry about that.
No problem. Thank you. Walk down.
Yep, he sent an email. He said that he has a referee hearing at 9, settlement conference. And lieutenant manager, and he log back in whenever he can between those hearings. You don't have email.
Okay, so